Radio, Television and Telecommunications Commission has rejected Bell's $3 billion bid to buy Astral Media. The stakes were high for Bell and for the company's major competitors, which had vigorously opposed the takeover. So why did the CRTC turn down the buy? Let's take a look at some of the reasons provided by the broadcast regulator. The CRTC said there was no evidence the deal would benefit consumers. The takeover could mean too much media concentration, and it raised concerns it would limit healthy competition. So is this decision a victory for Canadian consumers, or is it a blow to free enterprise and open markets? Joining me now is Michael Geist. He holds the Canada Research Chair in Internet and E-commerce Law at the University of Ottawa. Thanks for joining me today. Now, did the CRTC's decision surprise you? Let's just start with that.
Sure, I think it surprised just about everybody.
Yeah.
Not necessarily because of that there wasn't a case to be made that the CRTC ought to intervene and block the deal. I think there was actually a pretty compelling case for that, but simply because CRTC so rarely had jumped into these kinds of cases that most had almost seen it as akin to a rubber stamp. And for them to take on a big $3 billion deal, I think did catch many by surprise.
So what do you make of their reasons for rejecting this?
Well, I think what we're seeing is a real shift in perspective from the CRTC, where in the past it was largely about what's called the tangible benefits that might come out of one of these kinds of deals, essentially 10% skimmed off from the transaction or on top of the transaction that would go towards new production for television and potentially radio. And the public interest largely wasn't accounted for. The public, in a sense, would just stand on the side and there might be some trickle-down benefits, so to speak. In this instance, what we've got the CRTC, and they've been signaling it now for several months since they got their new chair, Jean-Pierre Blais, that consumers, that the public and the public interest is going to sit at the heart of their decision-making process, and they've come out with a real bang in this decision to show how that's done.
Yeah, I want to continue on with that. First, though, obviously Bell was not happy. Here's a part of what the company had to say in a statement. The CRTC's decision reflects bygone era based on antiquated working papers from the 1970s and 1980s that have little bearing on modern Canadian broadcasting and completely ignores its own most recent policy. Now, does Bell have a point? We were just talking about this in relying on old information and making new modern day decisions.
No, I don't think they were relying on old information. As part of the decision, they may have cited some of their earlier decisions to essentially make the case that they were empowered to do what they wanted to do. In many ways, what we had here was a new approach, not an old approach. The new approach where you had thousands of Canadians interjecting and speaking out. And really, seemingly for the first time, you had the chair literally reading some of the contributions from individual Canadians on these issues and asking company executives to respond to it. So it was certainly a new approach as part of the hearing process, and they relied on the law to assess the transaction on the basis of the public interest, but did so in a manner that we hadn't seen so much in recent years, where they focused more on the public interest side of it as opposed to the interests for the stakeholders and perhaps some who might benefit through these tangible benefits.
Would you say it's the CRTC essentially flexing its muscle?
Oh, absolutely. I think what we've seen in the few months now since Blais has taken over as commissioner is a very strong signal repeatedly now that consumers are going to sit at the heart of communications policy, both for broadcast and telecom. They introduced a new person in charge of consumer-related issues, so that lens comes out through policy decisions. They put forward a 3-year plan, their priorities plan, that put consumers at the heart of that as well. So they've started to send signals. They've sent several signals to the market that consumers are now a core part of what they're trying to do, and that clearly played a very big role in this decision as well.
So what's the downside of that?
I'm not sure that there is a downside to it. I think there's a big upside. I think for the first time, we now have a truly proactive, pro-consumer regulator at a time when you really need someone who is willing to step up and recognize that as things get more and more converged, we get more and more of this so-called vertical integration, that there can be some real negative effects for consumers, for creators, and for new competitors coming into the marketplace. And the CRTC served notice that they want to ensure that the public interest sits at the forefront of any of these policy decisions.
Now, Bell has also pushed for the federal cabinet to intervene, and let's remind the audience that the government has intervened in the past in and overruled CRTC in its Win Mobile ruling when the government basically vetoed a CRTC ruling on usage-based billing. Here's a part of a Conservative Party note that went out to its MPs to use as talking points. Take a look at this. Conservative Party talking points. The CRTC held public hearings and has rendered its decision on this matter. CRTC decisions are made independent of the Government of Canada. Cabinet has no legal ability to overturn this decision. Now, we hear that the Finance Minister would review this but wouldn't intervene on it. So why is the government so quick to distance itself?
Right. Well, I mean, I think there's a few things at play here. First off, there are a difference legally between telecommunications and broadcast. And so the examples you just raised are telecom. And so the power that the government had, for example, to impose its own decision is something that you might find in telecom, you might not find on the broadcast side. But I think further, actually, it was that usage-based billing decision, the one where you had hundreds of thousands of Canadians speaking out, that in some way was the wake-up call to say, you know what, the CRTC hasn't been adopting enough of a pro-consumer perspective or even using that as a lens for some of its decisions. And the government became far more involved quite clearly. And I have the sense that one of the things that they were looking for under the new CRTC was to say, you go do your thing, make sure that consumers are part of a big part of the sorts of things that you do, and we're going to be able to retreat and not play an active role. And so while it's certainly open to Bell to ask Cabinet to take a look at this and perhaps have Cabinet then ask the CRTC to take a second look, it seems to me that the government sent a very strong signal that it doesn't want to play in that sandbox anymore. It has given the marching orders to the CRTC and wants to let it go do its thing.
So what options does Bell have now?
Well, I mean, it has the ability to ask Cabinet, even though, of course, Cabinet sent a clear signal that's not going to go anywhere. It could go to the courts and ask, as part of an appeal, to say that somehow the CRTC decision itself was wrong at law. But it seems to me that has a very high standard or threshold that it's unlikely to be able to meet. Or it could try to rework the deal, but that's going to present a serious challenge as well. I mean, in many ways, it bet big on this transaction. It did so in a manner that focused not as much on the public interest side. I mean, the Commission heard from Canadians, it heard from a number of, obviously, its competitors, and at the end of the day concluded that Bell hadn't made the case. And in that sense, the deal may well be dead.
Michael Geist, thanks for going through this with us today. I appreciate your time.
Sure, my pleasure.